Silence, call tries.
My Lord, in these submissions, I shall deal with the three heads of appeal in the same order as my learned friend. The summary of my submissions is to be found at paragraph 4 of my skeleton argument. Dealing with the first ground of appeal, in relation to this ground, the respondent relies on two submissions. The first submission is that if the basic premise of the appellant's submission were correct, there would be recognition of it in the old cases of distress because of the application of the 1709 Act, but in fact there are not. There is no recognition of that. The second submission is that the approach of considering the exercise of CRA in isolation is wrong, and the authorities state that when considering an election, all of the circumstances should be considered. And when all the circumstances are considered in this case, it is clear that an affirmation of the tenancy is what occurred. My Lord, the law in relation to waiver of a right to forfeit a lease under an express power is tolerably clear in my submission. It's set out in my learned friend's skeleton argument, and there's been some exploration of the law as it stands already. So if it pleases your lordship, I'll simply refer to those cases that I wish to in my submissions, rather than set out the law as it stands now. The appellant's argument, the first submission, is that the appellant's argument seems to be that because circumstances exist under CRA where it can be exercised when the tenancy is not continuing, it can't operate as a waiver because the exercise of CRA itself therefore becomes equivocal. In my submission, however, this argument deals in absolutes. In my submission, it doesn't make allowances for the true facts known between the parties, and this is why the argument falls down. If the appellant's argument is correct, in my submission it must apply to the law of distress as it previously existed before the introduction of CRA. Since the implementation of the 1709 Act, distress could, in certain circumstances, be undertaken after the lease had been brought to an end. Therefore, following the appellant's logic, distress would not ever have operated as a waiver of the right to forfeit because it wasn't an unequivocal election. The mere fact that the statutory right under the 1709 Act existed in any circumstances would have made the Act equivocal. This, as we have touched on already, was the argument advanced in Doe on the demise of David and Williams, which is in my authority bundle at tab 11. I can invite you to turn to that.
Well, it wouldn't have applied in every case because the 1709 Act didn't apply in every case. It only applied when the lease came to an end, otherwise than by forfeiture. It only applied
when there were 6 months.
When there were 6 months in a row. It only applied in those circumstances, and also where the tenant remained in occupation, I think.
My Lord, as to the first and third of those points, I take your Lordship's point. But as to regard the second point, it could be a dispute between the parties as to how much rent was in arrear at the time. Yes. Indeed, that's the very circumstance of this case, of course. In that the tenant doesn't accept under any circumstances 6 months.
Well, we don't want to get a full statement in any judgment. I don't think it would apply in every case.
It
would apply in many cases. Is that enough?
The simple point I make in relation to David and Williams is is this. The fact of the case were that the tenant had disclaimed a lease in March of 1833. What he had done is said, I'm as much entitled to the premises of the lessor of the premises. So in modern day parlance, he'd denied his landlord's title. In November of that year, the landlord put in a distress for rent. So the question for the court was whether the landlord was entitled to rely on the disclaimer by the tenant as a ground to possession, or whether the subsequent distress waived it. The court held that the disclaimer was waived, but the relevant matter for the current case in my submission is one can see at the bottom of page 143 in the report the argument advanced by Mr. E.V. Williams for the lessor of the plaintiff. And the argument he raises is that distraining is not per se any acknowledgement of a tenancy or waiver of a disclaimer, for the distress may have been under the Statute of Anne after the expiration of the tenancy. While there is not a lot of detail in those two sentences, in my submission it is exactly the same point that my learned friend makes before this court today. Because there was an alternative way in which distress could have been executed, it couldn't have amounted to an acknowledgement of the tenancy.
Which court is this in?
This is in...
It looks like King's Bench.
Yes, it appears to be a first instance.
Common Pleas. It's a first instance decision. It's reported in Common Pleas and also in King's Bench. Hang on, referred to. Sorry, this is King's Bench, is it?
No. Yes.
Is it? Oh, anyway, we can find that out. Okay, it's first instance.
Well, Mr. Justice Patterson gives his short judgment over the page.
Do we know anything about him, Mr. Justice Patterson?
Well, no, I wasn't able to find anything. I did endeavour to, but...
You tried to find it.
He makes two findings. First, that the Statute of Anne does not apply when the tenancy has been brought to an end by disclaimer. And this case is in the textbooks because that is the point that's deemed the ratio of the case, that the Statute of Anne can't be exercised where a tenancy has been disclaimed.
And that SIC is cited. What is it? Do you know which textbook is it cited in?
It's cited in Woodfall.
For that proposition.
Well, yes. But the point that in my submission is relevant for your lordships is 3 lines up from the end of his judgment, the word non-suit, where he says, the mere act of distraining for rent prima facie recognises the distrainee as being a tenant of the distrainer at the time of the distress made. Now, his conclusion in my submission is that at the time the landlord was levying distress in this matter, he couldn't be levying it under the Statute of Anne because the Statute of Anne didn't apply if there'd been a disclaimer. But what he's saying is, in effect, the Statute of Anne doesn't apply on the facts of this case. The only possible argument as to the tenancy coming to an end was that it had come to an end by the tenant's disclaimer. And because that was not a manner under which distress under the statute could be exercised, it didn't apply. The point that is not stated in this judgment, but in my submission flows from it, is that the judge was not troubled by the hypothetical argument that the explanation for the distress could have been that it was under the Statute of Anne, because when he considered the facts of the case, he concluded those circumstances could not apply. to put that point another way,
Hang on, just could not apply. What was the, just run me through again the chronology.
I'll go through
Chronology was, when was the disclaimer?
because the disclaimer was in March 1833.
Approved disclaimer, witness called the statement was sent by the vessel to demand rent. And repeatedly said he was what to take those. That's a disclaimer. What does that mean, disclaimer?
In my submission, my understanding of it meant he was denying the landlord's title. Because if you read the judgment to prove the disclaimer, a witness was called who stated that when he was sent by the lesser of the plaintiff to demand rent from the defendant in the month of March 1833, and the defendant refused to pay the rent and said he was as much entitled to the premises as the lessor of the premises himself.
So it's a disclaimer of title.
My lord,
Disclaimer of
yes.
the landlord's title. Is that right?
My lord, yes.
And that was in March 1833. And when was the distraint?
November of 1833. If you follow on the sentence, this witness stated in his cross-examination that subsequent to this conversation, viz. In the March of November 1833, the lesser of the plaintiff had distrained on the defendant for.
When were the proceedings brought? Do we know that?
My lord, that does not appear in this.
He then gave notice to quit in September 1833.
Yes, the ejectment by the landlord against his tenant, the day of the demise laid in the declaration was the 3rd day of October 1833.
Where are you reading from then?
That's the first line of the report under the reference to Lewis and Davis in the 1913 2 KBW.
Day of the demise. So the day of the demise was the 3rd of October 1833.
My lord, as I understand things, in order to succeed on an action for an ejectment, at this time, the landlord had to prove title. And where it says the action is the day of the demise laid in the declaration, I had understood that to mean that is the day on which the action is brought, because that is the day on which the landlord is in these proceedings recording his demise.
So, and just on so the disclaimer is in March 1833. The next thing that happens is the action is brought in October 1833. Is that right? You're saying? And then the distress is November. Is that right?
My lord, yes. That appears, as I understand
So
it.
the distress was after he commenced the proceedings.
My lord, that simply can't be right, can it? So,
it can't be right.
Well, notice to quit was given, as you've said, on the 29th September. So we've got March was the demand, 29th September, notice to quit. Something on the 3rd of October, don't quite sure what. And then just...
Anyway, it may not matter the precise course of events.
those
Facts
are
unclear.
the only dates that are referred to in this short judgment. The simple point in my submission that this case illustrates is that the simple existence of the Statute of Anne, the very fact that it existed as a means of exercising distress after the end of the term, wasn't enough if the requirements to exercise that statute don't apply on the facts of the case.
I mean, the trouble with it is that it simply didn't apply at all. So it's not like our case, really.
Well, my lord, the reason I refer to it is because it is the only decision I can find where anything like the argument my learned friend is putting forward is advanced by a court. I do appreciate it's not a very satisfactory and reasoned decision, but it does, in my submission, appear to suggest that the argument didn't trouble the court.
But the judge didn't actually have to grapple with it, because by the time he gets on to the waiver point, he says, well, the statute is out of the picture entirely.
Well, I have to concede that. May I move on to the next authority, which is Croft and Lumley, which is in the appellant's bundle of authorities at tab 8.
Just one minute. So I just wanted, before you get there, so the point is that by the time of the by the time of the distress, by the time of the distress, the thing had already been disclaimed. Is that right? Simple. So the disclaimer was in March 1833.
The question, as I understood it,
The disclaimer was. When was the disclaimer?
I think
that was in March.
So that was in March. So when was the distress? I'm so sorry.
November.
The distress was November. So that's why the statute didn't apply. Really, at the time of the distress, the statute had no application.
Yes.
That's the point.
Well, no. The point
That is outside the Act.
The point is whether or not the distress waived the initial disclaimer by the tenant, or whether the landlord could rely on that to regain possession.
So the landlord was saying, I'm sorry, it's my fault, I'm probably being slow. The landlord was saying that the tenant's disclaimed, and I'm therefore entitled to possession.
Lord, yes. As well as serving a notice to quit. So the landlord put his possession action on two bases.
Yes.
You'll see the first line of Patterson, Mr. Justice Patterson, this notice is good for nothing. So he rules immediately that the notice to quit wasn't valid. So the next question he has to consider is whether or not the landlord is still entitled to possession on the basis of the earlier disclaimer.
Right, the point I'm trying to make is, I just don't fully understand the implications of what my lord was saying. The point is that from the time of the hypothesis we're proceeding on is that the landlord was proceeding on was that the lease had come to an end by disclaimer of his title.
Or that gave rise to right to forfeit. I mean, in modern terms, as you say, denial of title entitles you to forfeit.
Lord, yes. Unfortunately, that distinction isn't made clear in the report. The simple question that the court held was that the disclaimer was waived.
No, I know that, but I'm just trying to understand this one chronology. The chronology was the disclaimer, right to forfeit, the right to bring to an end, and then you've got this distress that comes afterwards. But the landlord, the point is that this was a case that was never within the Act.
The 1709.
Yes, because it didn't apply to terminations by disclaimer. That's what I'm trying to get.
That's correct.
Right. So the Act really never applied from the time that the act occurred, that the event occurred on which the landlord based its claim.
That is correct as a matter of fact, but it's not the point I'm making.
No, it's not the point you're making. I'm trying to understand. But the fact of the matter is, this case, therefore, is not directly in point. It's not analogous to our situation, where before CRA, the only point being made here is that the lease was forfeited, but didn't come to end by expiration of time. So the lease would have been within the Act. That's the distinction, isn't it? That's why it's not direct authority.
Well,
That's what I'm trying to understand.
What I say on the point is, yes, I agree with that analysis.
Right.
However, there is implicit in this judgment a rejection of the argument.
No, I appreciate that. No. I totally understand that. I'm just trying to nail down why it is that it's not actually on all fours with ours.
I'm backtracking and wondering whether it's closer to ours than I thought it was. In the sense that if you look at Greenwood and Moss, where this is referred to, this is
Greenwood and Moss is in the authorities bundle. Do you want to turn to any particular?
Cowan's Authorities Bundle, tab 10, page 365.
So this is.
Yes, this is a passage I had intended to take.
Yes, so they're taking this as authority for the proposition that the statute only applies in the case of determination of the tenancy in the ordinary course and not by forfeiture.
Oh, yes.
So, in modern terms, disclaimer gives rise to a right to forfeit. I dare say it did then too.
So where's the passage?
So this is
It's a page
6 lines down on page 365.
And is your lordship at the word therefore the whole case comes to this? Or slightly
I was starting at, my impression is that it would be unlawful for the reason suggested by Mr. Justice Patterson in Doe and Williams at Nyside Price, that the statute only applies in the case of the determination of the tenancy in the ordinary course and not by a forfeiture. So if Doe and Williams was a case where disclaimer gave rise to a right to forfeit, which I suppose it must have done, and then there was a waiver of the right to forfeit, there is a sort of matching. Here, the non-payment of rent gives rise to a right to forfeit. The question is whether that's been waived, and the statute doesn't apply in either case because it doesn't apply to forfeiture.
Yes, that's the point I was making, but in a roundabout way.
I think the David and Williams case, Friday I got was absolutely right, that had at the time of the distress in November, had the lease already come to an end by virtue of the tenant's denial of title and the landlord's exercise of his right. So he gave notice to quit. So it had come to an end. On the question, is that right or not?
Following it through, as a matter of law,
Yes.
there's a denial of title.
Yes.
There is then another act by the landlord which is said to affirm the lease.
No, hold on.
In
Sorry.
between
The
there-
notice to quit is irrelevant. The notice to quit was bad because it didn't terminate on an anniversary of the date of commencement. That's the
Okay.
point. It appeared that it gave the defendant notice to quit on the 29th of September 1830. The tenancy commenced on the 25th of March. So because it was, I don't know what it was, but it must have been a periodic tenancy of some sort, and so the notice had to coincide with an anniversary of the date of its commencement. That's why the notice was bad.
Apologies.
But the point I think still remains a valid one, although my lord's withdrawing from his comment, that the difference is that at the date of the distress, that either the event which had affected the forfeiture automatically terminated by, that's the disclaimer, had occurred, or it gave rise to a right to forfeit. It doesn't really matter for our purpose. It doesn't matter.
That's the point.
It doesn't matter.
The disclaimer by itself doesn't bring the tenancy to an end as a matter of law. It simply gives the landlord a right.
I don't think it matters but I'm saying whether it's on all fours or not, because what was clear is that the event on which the landlord was relying was outside, meant that the whole thing was outside the scope of the Act. Whereas in the case of arrears of rent, that's not true. The mere fact that there are arrears of rent doesn't take you outside the Act, I don't think.
That's correct, but the point, as I understood it being made by the appellant, is the very existence of the Act makes the election equivocal. The very power to be able to do something after the lease has come to an end. And therefore, whether or not as a matter of law and fact you could do that thing, is immaterial because the power to do it exists, whereas in this very short
I'm
judgment,
not sure if it was going as far as that. I mean, I'm not sure. I mean, maybe it was, but I mean, I thought he was simply saying, well, you know, when you forfeit for at the moment of distress for arrears of rent, you don't quite know what's going to happen. But you're right. No, it's true. He does say yes. The fact that in theory you could do this afterwards, that's true.
In the end, the lease is preserved.
yes.
So you say that, well, I have to think this through, but you say the distinction. We certainly got the point that the argument was advanced. We've got that point. We've got the point the argument was advanced, and the judge implicitly rejects that by saying the mere act of distraining for prima facie recognised distraining as being intended. So he's ignoring that argument. He's not answering that argument. He's saying that's what the mere fact of distraining, and so he's obviously rejecting the argument that was put forward by Mr. Williams.
Well, it is with such a scant report difficult to put suppositions in, but my submission is it must have occurred to the judge that there could be a set of facts where distraint could be exercised after the lease under the Statute of Anne. And simply because he decided the Statute of Anne didn't apply, he was only applying on this case and these set of facts.
And the reason it couldn't apply, was it wouldn't apply post-forfeiture.
Well, that's the point.
He's forfeiting.
Yes.
But
So he
one
says
has
it
to
only,
assume there is forfeiture.
it only
Forfeit,
applies
is that
where
right?
the tenancy has been determined by lapse of time or perhaps by notice to quit, and not where there's been wrongful disclaimer, which would give a rise to forfeiture.
Oh, yes.
Is that right?
That's
the analysis giving right to. Is that the correct analysis?
Oh,
That
yes.
it gives right to forfeit.
The express words "right to forfeit" are not mentioned.
No, but just as a matter of law, is that what happens
It
when
must be.
you disclaim the tenant, the landlord's title?
It must be, because if it brought the tenancy to an end, this debate would be irrelevant.
So the denial of title gives the landlord a right to forfeit. But in this case, the landlord had not exercised that right at the time that he distrained.
Oh, yes.
And therefore, the distress waived the right to forfeit.
Oh,
That was the decision in the case. And the argument based on the Act of 1709 didn't avail the landlord.
Exactly, Lord, yes.
Right. Well, you haven't got anything in the bundles about disclaimer of title.
No.
I need to look at that.
I mean, it is still the law that denial of title gives rise to a right to forfeit, and traditionally it was thought you couldn't get relief, wasn't it? But that's another story.
Without having as much preparation as I have for this particular matter, that's my understanding. I do have a copy of Woodfall next to me. If it's a matter that I can provide guidance on, I shall.
Look it up. No, don't you worry about it. So you say it's not so far away from the present case where, at the time of the disclaimer, at the time of the distress in the present case, there was a right to forfeit.
If one substitutes the wrongful act of the tenant, the disclaimer, as being not paying rent,
Yes.
in my submission, we're almost there. The difficulty, perhaps the confusion-causing element, is the wrongful act of the tenant, it being a disclaimer rather than a not paying rent.
Right. Okay. Thank you. Now, you want to refer to Grimwood and Moss?
No, not at this exact moment in time.
You don't want to refer to
I'll move
Grimwood?
to Croft and Lumley, if I may, which is behind tab 8
But who's bundle?
in the appellant's bundle.
One of the oddities is we've got quite a few authorities in both bundles. I don't quite know how we get to the point that there isn't an agreed bundle.
Well, I suspect that may be a fault of mine in that I was slightly later instructed than my learned friend, and I apologise to the court for that.
So this is Croft and Lumley. So this is another case in which Mr. Lumley was a litigant.
Well, I'd like to, if I may, take you to the judgment of...
Can we just see what it was about?
Well, yes. It's a complicated case involving a lease of an opera house where there were a number of alleged breaches of covenant.
So there are two non-breaches of covenant, and then another one. So it's the last bit, is it? And the head note, unless he tenders money in payment of rent due.
Well, yes.
With all these other ones, there's no breach of this covenant being committed.
The relevant section is at page 1475. Paragraph just above the bottom hole punch, beginning where a lessor has so conducted himself.
Who's giving this judgment?
This is the judgment of Mr. Justice Crompton. And the judgment starts 2 pages earlier at 1473.
It isn't strictly a judgment, is it? It's the House of Lords
It's an
asking the judges for their views.
It's an opinion, my lord,
Yep.
yes.
1472.
The opinion starts at 1472. 1473.
Okay.
Mr. Justice Crompton.
You want us to read from 1475,
My lord, yes.
where this, or just above the whole bunch?
My lord, yes. And it's the whole of the paragraph.
Right. What do you want to get out of
The
this?
sentence in my submission that will assist this court is the final sentence. A receipt of rent eo nomine as rent under the lease, at least if unaccompanied by any explanation, is an unequivocal act of electing to keep the reversion. So is a distress in a case where it can only be justified by the continuance of the tenancy. Now, there is a subtle distinction there in my submission, and it is the use of the words can only be justified by the continuance of the tenancy. Now, in my submission, the relevance of those words are that Mr. Justice Crompton is aware of the Statute of Anne and is saying, in effect, one has to consider, in a case of distress, the circumstances and go on to consider whether that distress can only be justified by the continuance of the tenancy.
The first part of that sentence is not strictly correct, is it? I thought that if you receive arrears of rent in relation to a period past rent, and you don't distrain, is that a waiver?
It depends on the period of time.
No, but if it relates, for example, if let's say you've got a certain amount of money in arrear, rent in arrear. Let's say you've got 2 quarters rent in arrear, and you're profiting, you take the rent for the earlier period. Is the acceptance of that rent a waiver?
There is authority on this point, and I'm struggling to recall.
I thought it wasn't. You see, that was the point. I thought it wasn't.
It is certainly right that once the time to forfeit for a period of rent has passed, any act in relation to the rent from that prior period cannot amount to a waiver because it's a prior period, and the right has.
What I was trying to suggest was that's why there's a difference between acceptance of rent or demand for rent in that situation and distress. Because if you were to distrain for that rent, that would be an affirmation, leaving aside more complicated about the 1709 Act, because you're re-entering at a time when you're saying you're entitled to forfeit.
Yes.
And your only right to re-enter is qua landlord.
Yes.
That I think my own feeling at the moment is that there is a fundamental distinction between demanding rent and actually re-entering. Certainly when it's in relation to an earlier period a period of rent which has passed.
In terms of one being a more restrictive, the difference in my submission is this: rent in the cases is always seen as a special class of substance. If you demand or accept rent, there is no inquiry into the surrounding circumstances. I simply say, in the case of distress, the court is entitled to inquire into the surrounding circumstances. But that's the only real point I make.
I'm just trying to understand the wider picture. Anyway, you say that these words, where it can only be justified by the continuance of the tenancy, suggests that he's aware that there are cases where you can distrain and it has nothing to do with the continuance of the tenancy. That's what you're saying.
Well,
And that must therefore be a reference to the 1709 Act.
Well, yes.
Right. Where does that get us to?
Well, it simply goes to show in my submission that the submissions being put forward by the appellant have been something that have been in the minds of the court, and the way they have dealt with them in my submission is to look at exercising a right of distraint as prima facie affirming the lease, save where the circumstances dictate otherwise.
I got that point.
The 1709 Act, sorry, that, just remind me, I'm getting quite confused.
1709 Act allows distress after the end of the tenancy.
But he can't have been referring to it there, can he? Because if the tenancy has come to an end, then obviously distress under the Act can't be a waiver, because it's come to an end.
Well, my lord, I do see the point, and it does seem very obvious.
The 1852 Act. in some way.
The difficulty is, as I understand the submissions, the way they have been put by the appellant and those that I'm responding to, are that there is this twilight zone where the landlord can consider his own position. And the way I have attempted to reconcile that in a factual circumstance is this. Supposing a landlord was entitled to serve a notice to quit under a tenancy and served that notice to quit, but the tenant never received it, didn't know that the notice to quit had been served. The landlord may believe, quite properly, the tenancy had been brought to an end, but the tenant wouldn't know. In those circumstances, if the landlord exercised distress, he could quite properly say, I understood I was exercising distress under the 1709 Act, because I understood the tenancy to be brought to an end. QED, I am not affirming the continuation of the tenancy. That is how I understood the appellant submissions to be brought. Now, what I say is, well, in those very rare circumstances, that may well occur. But those circumstances are very rare, and the court are right to inquire as to the totality of those circumstances before considering whether or not the act amounts to an affirmation.
Again, it all seems to be becoming so complicated, and it doesn't need to be.
I apologise, Your Lordship. I think I'm trying to strain out of cases where the matter is not clear implied reasoning, and that's
Can I just go back to my Lord's point? So, yes. So what are these words referring to? So he's talking about when would an act of distress be an unequivocal act of electing to keep the reversion. That's what we're looking at. When would a distress be an unequivocal act? And he said it would be in cases where it can only be justified by the continuance of the tenancy. And the question is, what do those words mean? You say it must be the 1709 Act. The point that's made by my Lord is, well, yes, but if you're looking at the if you're looking at the post-termination right to exercise distress, that couldn't be an unequivocal act of electing to keep the reversion. Where it can only be justified by the continuance of the tenancy. So you're saying, therefore, it's in cases other than, it's in a situation where it's not the additional part added by the 1709 Act.
Well, there is a, to work an example, there is a distress. That distress, at common law, can only be justified by the continuation of the tenancy because it's the common law. So is there a circumstance where distress can be levied where it's not justified by the continuation of the tenancy? Well, in my submission, yes, but only under the 1709 Act. If
that's the bit I don't understand, but because for the 1709 Act to apply, the lease has come to an end.
yes, forgive me. I think.
I mean,
But in those circumstances, if it's come to an end, you say, well, if it's come to an end, that is a circumstance where the distress is not unequivocal because it is justified by circumstances other than the
My Lord,
continuation
yes,
of tenancy.
that's
the point.
I see, right.
That's the point that's being made.
as I said.
So in those circumstances, it's not
I
only
see.
justified by
All
the
right.
tenancy, but
Yes.
This chimes with the passage that I think Mr. Cowan referred to in his skeleton from Baron Bramwell back at 1472, where you get as distraining for rent not under the Statute of Anne.
My Lord, yes. Do you want me to deal with that?
No, well, it may be the same point.
It's the same point.
Yes.
It's just words in parenthesis. Do they make a specific point, or do they simply exclude something that couldn't happen anyway?
Yes.
And that's a semantic.
I understand now why you, but I'm inclined to think that Croft and Lumley doesn't take us very much further. We're trying to discern exactly what was meant by
That may well be the case. My job, as I understand it, is to respond to the arguments put forward, and that is an argument put forward, and that's why I say, with all due respect, in my submission, it could mean anything. In reality, may I move on to the third and final case that I wish to take the court to, and this is Warden Day, which is behind the next tab 9.
yes, Warden Day.
Now, it may be that your lordship have the facts from the discussion that was had with my learned friend, but my understanding of the facts, just to confirm them, was the question for the court here were whether two matters amounted to a waiver of a right to bring a licence, a mining licence, to an end.
Yes.
And the two matters were, firstly, the fact that a distraint was undertaken, albeit illegally, and the second was the fact that the licensor negotiated a new licence to take effect.
Continuing to
at the
negotiate. He was continuing to negotiate. the terms of the
Obviously, we can put the negotiation point aside, but it's important to understand that when reading the judgments. Now, the other point to note here is that the forfeiture provision, as discussed, wasn't a standard forfeiture provision in that it didn't contain a right simply to re-enter on the premises. It was a right to serve written notice to determine the grant. And we can see that from page 486, first page of the judgment, in the head note. After the words on the fifth line, the 25th of December, with a proviso that if any part of the rent should be in arrear for 21 days, it should be lawful for B, his heirs and assigns, by notice in writing delivered to A to determine the grant.
Yes.
Now, at page 491, this is the judgment again of Mr. Justice Crompton. It's the same judge we've been referring to in the previous case. He makes just one very simple point, which is that whether the plaintiff determined by licence by entry or by formal notice, which is a more roundabout ceremony, it's conceded that the right of determining the licence was an option, and therefore must be looked at as a case of election.
So where are you reading from now?
I do beg your pardon. It's 8 lines up from the bottom of page 491. The words, whether the plaintiff determined the licence by entry. And that doesn't take us any further, save to say that Mr. Justice Crompton was considering this as a matter of election, which is the matter before your lordships today. And over the page at 492, there is a paragraph that begins just where the first hole punch is, after the words cited in Plowden 133, beginning according to the doctrine of election.
Yes.
You want us to read this?
That paragraph, my lord, yes.
What
You
from
say
there?
Yeah, to the end of that paragraph.
To the end of that, to the end of such a case as this.
Yes, okay.
So the question the courts are asking themselves is whether or not the doctrine that waiver exists on account of the fact that distress is levied applies or would have applied if this were a lease. And the key word, of course, the sentence, of course, is I should have had no doubt that the latter doctrine applied to the present case, except that it is possible that the plaintiff might suppose that he had a right to distrain under the statute of Anne for half a year's rent 6 months after the termination of the grant.
Does the 1709 Act apply to licences?
No, it doesn't.
That's the whole point. That's why it was unlawful, the distress.
But they're discussing this obiter if it were a lease. in my submission, the use of the words possibly the plaintiff might suppose returns to the reasoning in the cases prior, which is prima facie it's inconsistent to exercise distress without asserting the lease continues, but in certain circumstances, if the factual circumstances prevail and the plaintiff does suppose, that presumption could be rebutted.
What have you got out of this so far? You say that you've got out of it that, okay, he's treating it as a case of election. You got that out of it. And then there's a whole series of stuff here where he's talking about distress generally, although it's a license, which seems a very odd concept to me. And he's talking about he's dealing with the doctrine of waiver by distress and waiver by receipt of rent, two different principles, he says. This is the point. Waiver by receipt of rent only applies to rent occurring subsequent to the forfeiture, and that is not the present case. No inconsistency in a man who is given notice to tenant as receiving rent due before the supposed determination of it. There is no waiver by receiving that rent expressly. That's what I was trying to put to you. Waiver by distress must have got a different principle. Distress, we were teasing out before, that distress is different. And then you've got this last bit about according to the doctrine of election. All right. And then the doctrine of waiver rests on the inconsistency of a man saying about stress tendencies. Right. I should have no doubt that the latter doctrine, that's the election one, applies to the present case, except that it is possible that the plaintiff might suppose that he had a right to distrain under for the half year's rent as a consequence if the grantee continued in possession. Well, I'm not sure what we're to get out of that.
Well, may I take you to...
I mean, that sounds like there's musings to me.
May I take you to the judgment of Mr. Justice Blackburn at page 494 and the paragraph that we have looked at. I might make this point. What I'm going to say is that Mr. Justice Crompton asks a question but doesn't answer it.
That's right.
And Mr. Justice Blackburn poses an answer to that same question.
Quite. Yeah, so that is correct, I think. And that's on 494.
Lord, yes.
And we've read this passage, and
Well,
basically
yes.
you say that when he says, I incline to think that it would, he is rejecting the proposition, or he's accepting his own proposition, that if a landlord distrained...
what I say, my lord, is he says in terms, it's a question of evidence, because he is entitling himself to consider the factual circumstances. If this had been a lease, another question would have arisen, whether or not, in as much as the statute of Anne, a landlord may distrain within 6 months after the lease is determined. The fact of making a distress within 6 months after the forfeiture accrued would be sufficient evidence that the landlord was treating the estate as continuing. In other words, in the circumstances of this case, irrespective of the statute of Anne, the fact of making the distress in this case would be sufficient evidence that the landlord is treating the estate as continuing.
I don't know. I think he's actually... I'm not sure you're right about it. I think he's posing the general hypothetical case. Then he goes on and he says, but when we have also what tends to show the plaintiff considered, then he goes on to treat the actual facts.
Well, he says, I am inclined to think it would, but when we have the other facts. Now, In my submission, he's right to be inclined to think it would on the facts, because what we know about this case is there is no other way in which the landlord could have brought the lease to an end, save by relying on the right of forfeiture.
That's right.
So to consider the point of whether or not it's amounted to an affirmation of the lease, the distress, considering the evidence, even though the statute of Anne exists, he's inclined to think it would be an affirmation that the landlord was treating the estate as
That's what it says.
Okay.
Yes.
Can I just ask a question that I think I know the answer, but to be absolutely clear about this, when Mr. Justice Blackburn says the fact of making a distress within 6 months after the forfeiture accrued, that means after the right to forfeit accrued, not after it had been exercised.
No.
Well, this is the whole point. Ex
I agree.
hypothesi, he hasn't re-entered.
Well, yes.
That's the whole point here. He hasn't re-entered.
Quite.
And so he's hypothesising a situation where the landlord hasn't re-entered, but more than 6 months' rent has accrued due, and he then goes in the belief that he's got the right under the Act, the 1709 Act. So a landlord, a landlord may distrain within 6 months after these. Sorry, the fact of making a distress within 6 months after the forfeiture accrued, i.e. rights accrued, question would be sufficient evidence that the landlord was treating the estate as continuing, even though he was acting under the impression that the estate had come to an end, but by virtue of the statute he could distrain within 6 months of the termination. In other words, the landlord's acting under a misapprehension about his rights.
It's all a hypothetical thing because the landlord didn't re-enter under the statute of Anne. It was simply an argument raised, as it has been in this appeal.
Yes, he's raising it as a general. What would be the position, he's saying, if 6 months' rent is accrued due, the landlord thinks he's got a right, by virtue of the 1709 Act, to distrain without electing to determine the lease, without intending to determine the lease. So he's acting under that misapprehension. Would that amount to a waiver or not? And he's saying, well, it would amount to a waiver. It would amount to a waiver of the right and an affirmation of the lease. That's as I understand what he's saying.
Yeah.
Notwithstanding the landlord, notwithstanding there are 6 months in rent in arrears, that there's no reason why the Act shouldn't apply in theory, but actually the Act isn't applying. That would be an affirmation. And that's as simple as I understand.
Because the Act could only apply if the tenancy had returned.
Right.
Yes.
And I think, is it right that Mr. Justice Blackburn is postulating that the landlord is acting under a misapprehension? He thinks it has returned, and he's exercising rights under the Act of Queen Anne.
My Lord, no, I don't think that's right. I think he's postulating the exact question that my learned friend is putting to this court, that because a manner in which distress can be undertaken after the lease has ended, because that exists, it can't be, the mere act of distress can't be a positive affirmation of the continuing.
He doesn't say that. I mean, you're reading. It doesn't. The point is, I don't think it matters. I don't think it matters whether it's it's what Mr. Cohen is saying here, or the wording seems to say, the landlord's under a misapprehension. It doesn't matter, because he's basically saying, look, we're assuming 6 months is in arrear, or that I think is the assumption he's making. 6 months is in arrear. The landlord either thinks he would have, or he thinks he has had. He does have a right to determine, to go in and exercise distress under the 1709. It doesn't matter, because on either footing he comes to the conclusion that still would amount to an affirmation, because it's objective.
Yes, yes. Exactly, I mean, in effect, the landlord can't take advantage of his own mistake. I mean, if
Yes.
it's postulating that he thinks that he's got the right to stray, when he hasn't, he can't therefore rely on that. But I mean, it all boils back to this, isn't it? But the right of distress under the Act of Queen Anne arises only after the lease has terminated.
That's the simple.
Even if the lease hasn't terminated, it's actually by the by.
My lord, yes, and those are facts that the court needs to consider,
Yeah.
whether considering what the objective
Yeah.
act communicated to the tenant was.
Right, there we've got that case. Next one.
My lord, those are my submissions, and I echo back.
Well, I think your best cases then are that dictum of Lord Justice Blackburn and the Doe case.
My lord,
Is that right? Are those the best ones for you?
my lord, yes. Those are my submissions on the old cases of distress. I now move on to my second submission, which is, rather than looking at the old cases under distress, it's a better exercise simply to consider the quality of the acts undertaken by the landlord in the factual matrix in which they were undertaken. And those factual matrix, that factual matrix includes the following facts. First, and I'll take your lordships to it if you want, but I'll just give you the page reference otherwise. At page 159, the term of the lease was to run until the 16th of May 2034.
16th of May, 34.
Secondly, at page 160, the permitted user was a retail shop.
Which clause?
Page 160, I'll tell you.
Don't worry, we can look it up. Yeah, page 160.
It's
yeah.
the user clause. It's a,
Yeah, user.
and there is a covenant to keep the shop open.
Yes.
And the tenancy is not excluded from the Landlord and Tenant Act 1954.
Right. Why is that all relevant?
It's relevant because the only way in which the landlord could have unilaterally brought the tenancy to an end is by forfeiture.
Oh, I see.
So as at the material date that we're all concerned with,
Yes.
and it's submitted once that factor is taken account of, that the only manner in which the lease could be brought to an end is forfeiture, the act of the landlord in this case, in exercising CRA, does become unequivocal. Because there's no possibility CRA was being or could have been exercised after the end of the tenancy. Because there's simply no way the landlord could have brought this tenancy to an end. And that must mean that the landlord was electing to affirm the tenancy. That's the totality of the act that the landlord is undertaking and communicating to the tenant, not simply exercising CRA in a vacuum, where in certain circumstances it could be undertaken at the end of the lease, and at certain circumstances before. And if I can invite you to turn to page 125 of the appeal bundle and the judgment of Mr. Justice Marcus Smith.
Which paragraph?
Paragraph 28 and 29.
Thank you.
That, in my submission, is exactly what he is saying.
And in a way, you've added another point. that even if the lease were terminated, that could only be by forfeiture, and even then, CRA could not be exercised.
Well, my lord, exactly.
I mean, that's not spelt out by the judge.
It's not spelt out by the judge, but in my submission, it must be implicit in his reasoning.
Well, it may or may not. Forgive me. It may or may not be. It may be that the judge felt that 1, 2, and 3, as he expresses them, is enough. But I think you're adding, well, even if you do look forward, CRA was not capable of being exercised in this case, because forfeiture was the only way the lease could be terminated. Isn't that?
Well,
that's what you're
I mean, I say that, I say more, because CRA cannot be exercised after forfeiture.
That's right.
There is a specific election, or a specific representation to the tenant that the lease is not being ended by forfeiture. Because if it was, CRA couldn't be exercised.
Yeah, I find that's yes.
That I certainly follow. Going back to your earlier point, which I was very tempted by a moment ago, but now I'm backtracking on that one as well. Which bit do you attach importance to? The fact that the term hasn't yet come to an end, but that's going to be true always. The fact that it's protected by the Landlord and Tenant Act, but that just requires a different kind of notice, and if the tenant doesn't then object, the thing comes to an end.
Well, the reason I make that point is because of what Mr. Justice Marcus Smith says in paragraph 29. And what he says is, while in a theoretical world it is possible to conceive of facts that could justify the exercise of CRA after the lease is ended, those facts do not pertain
So
in this
that
case.
could be a reference to the 79.41 point. Probably is.
He seems to consider that there is a set of hypothetical facts that could exist, that could explain this. I struggle to think of what they are in this modern age of protected commercial tenancies.
But I'm not sure what's special about this case. I mean, the term hadn't yet expired, but that's going to be the case always. It's Landlord and Tenant Act protected, but that doesn't mean a tenant has to object to a notice.
But no notice has been served. And the point is, what else could the landlord be representing when exercising CRA other than the lease was continuing? Is it possible the landlord could be representing, or could even have in his own mind, that the tenancy had already come to an end and he was exercising CRA under the exceptions to CRA which allow it to continue at the end of the tenancy? And it's very difficult to conceive of a situation where that would occur, but that must be what's occurred in order for the appellant's argument to succeed, in my
I mean, I follow that there could be the very rare case of the kind you referred to earlier, but that apart, I suspect.
So what was that? Could you repeat? What was that very rare?
where the landlord where there was a possibility, because it wasn't protected or something, that the landlord could serve a notice to quit that the landlord believed had brought the tenancy to an end, but wasn't actually served on the tenant, so the tenant didn't know that the landlord was under the impression the tenancy had been brought to an end, and then the landlord exercises CRA, believing he is acting under the exceptions, whereas the tenant believes he's acting and affirming the lease. That's the only situation I could conceive of where it wouldn't be an affirmation that the lease is continuing, because one could say, in the landlord's own mind, insofar as you're allowed to dwell in.
You're not allowed to look at the landlord's mind.
Well,
why are we hypothesising something we're not allowed to do?
well, it's very difficult to put any other meaning on, while in a theoretical world it's possible to
Well,
conceive
maybe
of
we don't need to.
I may be taking this submission too far.
Yeah.
I mean, I wonder whether really it isn't anything special about this particular case. There is, if you're right, a more general principle that the theoretical possibility that CRA might be exercised in certain circumstances doesn't prevent waiver, because necessarily CRA only applies post-termination if there hasn't been forfeiture.
Well, my lord, yes, I see the strength of that point. The other matter I wanted to take your lordships to.
I don't think that point detracts from what is actually a very simple factual proposition. proposition, which is we're all dealing here, and it may be in every other case whatsoever, but we're dealing on the facts with a situation where the distraint takes place before the lease has come to an end, which would then engage right under CRA to distract after the termination of the lease. I mean, that's the factual situation we're in. And maybe that's in every case. It doesn't detract from a general proposition, which is you've got to have regard to the actual facts, and that's the fact.
Yes, that's the simple point. You've got to have regard to the actual facts. And I was going to take you to...
You don't ignore, and that brings in, and I think one added force is given to that point by the fact that you can't, I'd have to work it through, but I think added force is given to that you can't, not only has the lease not come to an end, but you could never have a situation where there's a right to distrain under CRA if the lease has been forfeited.
Exactly.
That's the sort of additional. Not only has it not come to an end, so you're not actually within the second limb of CRA, as it were, if I call it the second limb of CRA, but actually, even if it had been brought to an end, hypothetically, what would be the position if we brought it to an end? But it can only be brought to an end by forfeiture, and CRA doesn't apply. That's it, isn't it?
Yes, your Lordship has
That's the only relevance of the actual facts.
Well,
You don't
yes.
ignore that actual fact because it's critical to the whole analysis.
Exactly. But as I say, my understanding of my learned friend's argument was you have to just look at these things in isolation.
Oh, no, I appreciate that.
And that's why I say, well, that would be
Is there
bizarre.
anything I've missed in that rather simple? Because I want to make sure I've got down all.
No,
Is there anything I've missed on that analysis of yours?
well, the only thing I would draw your Lordship's attention to is the comments of Lord Justice Slade in Expert Clothing Service and Sale and Hillgate House, which is behind tab 16.
In your one, or
My Lord, yes.
that's the back.
So just to polish off that last point, I'm sorry, just to polish off that last point. So are you saying that Mr. Justice Marshall Smith was actually wrong to postulate there might be circumstances where?
I wouldn't be so bold as to suggest
Where
just because I couldn't think of something doesn't mean it doesn't exist.
No, but we have to get it right.
I mean, if we'd got to 2035, with 6 months rent in arrear, and the tenant's still in occupation, even though his lease is ended, I suppose.
We'd be protected by the 54 Act, so...
But then the tenancy would continue. But
The whole sentence is a very odd one. In my judgment, the appellant's exercise of crime in this case contains an unequivocal representation of lease of tenants continuing. That's fine as far as you're concerned. It says, whilst in the theoretical world it is possible to conceive facts that would justify the exercise after the lease is ended, well, those are the facts stated in the legislation. If it's come to an end, 6 months rent, I mean, those are the facts. I don't understand why he says, whilst in a theoretical world it is possible to conceive of facts. CRA occurs after the lease has ended in the circumstances specified in the Act.
The theoretical world as opposed to the actual world of the facts of this case. That's the only thing I can...
I think that's what he is saying. Yeah.
It's the most odd expression to say in a theoretical world. I mean, I think at the moment I'm going to interpret that as me, and the only way you can give sense to that is, well, the theoretical world are where the facts of the statute are expressly, the express terms of the statute are satisfied.
My Lord, yes.
Yes.
But otherwise not. Right, so I wish I could get all these points. One moment while I write this down. Thank you.
Yes, my Lord. The final authority for return
Excellent.
submission, tab 16, Expert Clothing Limited in Hillgate House.
Yes.
At page 360,
What's this all about?
This is a case where there was a forfeiture of the lease, or a forfeiture event took place, and there were correspondence between the parties as to whether or not the lease was continuing, and it was about whether or not that could amount to a waiver of the right to forfeit.
Right.
And the simple point that Lord Justice Slade makes just below letter E on page 360. Just above letter E, the entire paragraph. He says, Mr. Collins, who's for one of the parties, is right in submitting that cases where there's been an acceptance of rent fall into a special category, and the establishment. Just above letter E on page 360.
Yes. Oh, sorry.
Being,
Sorry,
however,
yes,
I think, Mr. Collins.
Thank you.
Does your lordship have it?
Yeah.
The second sentence of that begins in the present case. In the present case where no acceptance of rent or demand for rent is involved, the court is, I think, free to look at all the circumstances of the case to consider whether the act of the plaintiff's solicitors relied on, the sending of the letters, was so unequivocal that when considered objectively, it could only be regarded as having been done consistently with the continued existence of the tenancy.
Well, I don't know. I mean, that is where he's not got distress in mind there. I mean, they're talking about a letter being sent. But what happened in this case, I understand it from a very quick reading of the head note while you were speaking, is that the landlords purported to re-enter the premises for failure to pay rent. There was then proceedings for possession were brought and they were settled, and a consent order was drawn up involving variation of the lease. And there's then things going backwards between the solicitors to agree the terms of their variation, and then this letter on the 22nd of October, the solicitors acting for the plaintiffs in the preparation of the deed of variation sent a letter stating they arranged for the plaintiffs to see the deed of variation. There was then proceedings were then brought for possession of the premises, blah blah blah, and one of the questions was, had any right to forfeit been waived by the sending of that letter? That was the background to it all. But I mean, we know that that distress is a special category at common law.
At common law, but we're talking about CRA, of course, and the point my learned friend made is that you should distinguish all the previous cases, notwithstanding the subject matter appears to be virtually identical, and consider CRA as a special case.
No.
I'm
Be
saying
slightly careful here. So, this is a point that this is also a point that I'm slightly balking up with Mr. Cowan when you say this is a special case. Whether something amounts or does not amount to an election is not a matter of statute. That's a common law issue.
Exactly.
While the factual circumstances may arise out of, that is, whether or not, in what circumstances you can exercise distraint may arise out of statute, we're concerned with common law principles of what amounts to a waiver. So
My Lord, just forgive me, I misunderstood your Lordship's
and
comment.
all I'm saying is that in relation to what constitutes a waiver, whether it's distress at common law or it's CRA under the statute, we know, because we have to work out the principle, that going into the other person's property, which ex hypothesi you've let to them under a tenancy, has a different quality or is different from other acts. That's a common law analysis. That's nothing to do with the statute.
My Lord, yes.
That's my proposition to you.
My Lord, I agree entirely. And all I say, the only purpose for raising this case is that in all circumstances under the common law, the court is entitled to consider all of the factual circumstances.
Yeah, but I'm sorry to say that, I just think this is a complication. What we have here is somebody who is gone onto the property of somebody who at the time they went onto the property had let it. That's what's indisputable. And you've got to work out, well, by what right did they go onto the property? As you quite rightly point out, it wasn't by any term of the lease. It couldn't do. So it could only be unlawful, an unlawful entry, which is what apparently Mr. Cowan is saying, that it was an unlawful entry, or it was a lawful entry under CRA. I mean, that seems to me to be the proper analysis. Now, if you're saying, well, those are the actual facts, I couldn't dissent from that. I mean, that's right. Those are the facts we're looking at. And that simply leads into your previous proposition, which is, yes, we are dealing with a case where there's been a re-entry, where there's arrears of rent giving rise to a right to forfeit. That's the facts. But is it more than that?
Oh, no. I simply wanted to bring this case to your lordship's attention so you're aware of what had been said about matters that could be
I don't think that would
considered.
take so much.
If it doesn't take any matters,
But that's my own view, but I mean others may disagree.
well, those are my submissions on the first ground. I suspect I shall be far briefer on ground, the next two grounds. And I'll take them, as my learned friend did, at ground 3, first of all, which is dealing with rights granted under section 210 of the Common Law Procedure Act 1852.
Yes.
May I begin by inviting your lordships to look at page 127 in the judgment of Mr. Justice Marcus Smith, at paragraph 37. So that's 127, page 127.
Paragraph 37.
That's correct, my lord,
Thank
yes. Because I can do no more than commend the reasoning there.
Sorry, did you need 37?
Yes. Had the appellants invoked section 210?
This is on page 139.
127, paragraph 37.
Oh, what have I got here? I'm looking at something else, haven't I? Have I got this mixed up with something else? Oh, I see. It's something. Oh, I've got Judge Madge mixed up with this. My fault. I'm so sorry. Yes.
Now, I don't know if your lordships require me to take you back to Thomas and Lullen, but the short concurring judgment of Lord Elisha, the Master of the Words, at the time, in my submission, simply shows the basis upon which Mr. Justice Marcus Smith was talking. He talks about invoking section 210, but the point he makes is the point that I commend to your lordships, which is this. A right of re-entry arises when the rent isn't paid. And for ease, I'll refer to that as right A, the right of re-entry that arises under the lease. The landlord exercises CRA. At that point, the landlord waives the right to rely on right A, the right to re-enter. However, right B, which is the right under the common law, under section 210, has not yet even arisen, because it only arises when a writ is served. So one can see a situation where the act of CRA waives the initial right of re-entry under the lease, but does not waive, because it is a precursor to, the issuing of a writ under section 210. And that is why Mr. Justice Marcus Smith says, had the appellants invoked section 210, then their prior use of CRA would not have precluded this.
Well, I wonder if you're. Can I just test the way you've put that?
Lord, yes.
You said the right under section 200 only arises when the writ is served. But my query is whether that's a correct way of putting it. The right to the section 210 rights arise in 4 circumstances where 6 months in arrear, tenant still in possession, etc. There are about 4 different circumstances. And what section 210 is really saying is, in that action for possession, it is no defence for the tenant to say you've waived because you sought to distrain. So it's not really that the right arises to distrain, it's that it ceases to be an effective defence to an action for ejectment.
Well, my lord, the way I interpreted it falls to the way I read section 210 itself, because my understanding of this section, which I did not have a lot of time or involvement with before this case, was that the entire purpose of it was to do away with the strictures of making a demand for rent at common law. Because what the section says, and it obviously it will assist us if we look at that, it's behind tab 2 in my bundle.
Well, why don't we look at the appellant's authority, because that's what we'd have looked at. So that's in tab 2.
Behind tab 2 in both bundles, in fact. In all cases, and so on and so forth. But the point is that
Does away with the need for a formal demand.
Without any formal demand or re-entry, serve a written ejectment for the recovery of the demised premises, which service shall stand in the place instead of a demand and re-entry.
Yes. Well, I'm not disputing the end result you get to. I'm just querying whether you're expressing it. I'm querying whether you're saying the right to distrain without waiver only arise in these cases. I'm wondering whether it's not better to say it's that in a case for ejectment, it's not a defence of waiver in those circumstances.
My lord, yes, save that the way I put the argument is that one cannot waive something that hasn't yet occurred, and the right to forfeiture under the statute doesn't occur until the writ is served. Now, that may simply be a semantic difference, but that's why I refer to them as right A and right B.
But you cannot waive something which hasn't yet occurred, and that something you're saying is what? The right to serve, the right to.
Perhaps I can put it this way:
right to recover possession.
Under a modern lease, rent is due whether demanded or not.
Yes.
That wasn't always the case, and that is the mischief in my submission that Section 210 was actually addressing, because landlords were finding that they couldn't actually bring an action unless they served a demand in accordance with the common law, which has extremely onerous requirements. And as such, the service of the writ wrapped up in that the need to serve a demand, which would have been a prerequisite of the rent falling due and a prerequisite of the right to forfeiture accruing.
I mean, you say, and I'm not surprised, that you haven't had much to do with the Common Law Procedure Act hitherto. So why isn't it used? I mean, so it's a landlord who's owed rent can safely send in enforcement agents to try to recover what they can. It doesn't run the risk of losing the right to forfeit because he can use the 1852 Act.
Oh yes, and clearly that was in the view of the draftsman because of the amendment to 210A, which specifically makes reference to CRA.
Yes.
But this is not. It says I myself haven't had to deal with 210. of it. I can't even think when I was in practice at the bar that I really looked at it. But just looking at it here now, it talks about in case of judgment against the defendant for non-appearance. Now, those words seem to govern everything that comes afterwards. Is that right? So maybe, can you see this at the top of
Yes.
page 50 internal numbering, and numbering at the top of the page?
I don't think it does actually, because I think it's in case of judgment against the defendant for non-appearance, if it shall be made clear to the court where the said action is depending by affidavit, or be proved upon the trial in case the defendant appears.
Oh, I see, yes, oh, I see.
So they're simply allowing
You're
an
right.
affidavit instead of all
I see,
evidence.
you're quite right.
Well, I suppose the landlord doesn't normally want to wait for 6 months' rent to be outstanding.
Yes, is all I can say to that. Being commercially realistic about it. Yes, because of course the right to forfeit arises. The landlord can either forfeit or not. In my submission, the right to exercise CRA waives the initial right to forfeit. But if upon exercising CRA, the landlord then wishes to engage the mechanism of this act, there's
He
no
can do
bar.
so.
He can do so.
Yeah, and that was Lord Isher's one, right?
My lord, yes.
You rest. I mean, your answer is Lord Isher's.
My lord, yes. That's why I quoted the.
You remember that passage where he says that the right conferred by this statute
It's different from
is
common.
an independent right.
Yeah, but I'm at the moment I'm stuck, I'm afraid, on the point about how you characterise this. And at the moment as I read it, it says, well, if you've got 6 months' rent in arrear, then what the landlord can do is it can serve this writ, and if at the trial you prove the half year's rent, one or other of the conditions in section 2.1 was met in relation to arrears, and the lessor had power to re-enter, then he recovers possession in the same manner as if the rent had been legally demanded. So you can't say, I'm not sure it says you create this right upon service of the writ. It's just it follows as a matter of inference, statutory inference, that by virtue of that you don't waive the right of re-entry if you have in fact sought to exercise distress. That's all I'm saying.
I see the point, and
That's
in
what
my
I'm saying.
submission, I don't need to take it any further because the end result we arrive at is the same.
I think it is the same. That I'm not querying the end result. It's just because I know there is authority, and I can't remember where I saw it. But there's authority for saying that the right under section 210 to get judgment without prior service of a notice depends on 4 factors, and they are, and one of them is not service of the writ. There are other factors, substantive factors of that you've got a right to non-payment of rent, 6 months in arrear, and at least a half year, and that the tenant's still in occupation.
I'm not sure that is found.
That I think there were 4. So I'm saying is that when they say that, that's when your rights arise, and it's just by statutory inference that it's plain, therefore, that you're not precluded from getting possession in those proceedings by virtue of having tried to get your money back by distraining. That's all.
Oh, yes.
But anyway, that's what I feel at the moment. I don't think it changes the end result at all.
Those are my submissions on the third.
Ground 3.
Ground 3.
What about ground 2?
Ground 2, I make one short submission. It appears that the point taken is the question is whether the landlord has communicated something to the tenant by its acts. And my submission is that the answer to this is in the pleadings. And if I may draw your attention to page 147 of the bundle.
We're looking at the core bundle.
Oh, yes.
Which page?
147. must be remembered that the appellant's point is about the knowledge of the tenant by the recovery agents attending.
Yes.
The claimant, respondent's point, the tenant's point, made in the pleadings at paragraph 12 is that on the 1st of February, enforcement agents attended the premises, took control of the goods belonging to the claimant by removing them from the premises. On the same day, the claimant was provided with an inventory of the controlled goods, which stated an outstanding sum owed to the defendants to be 8270 and total sum outstanding, etc. It's preceded by the aversion at paragraph 11. On the 18th of January 2016, the defendants instructed enforcement agents to exercise CRA. And those paragraphs are admitted by the defence at page 199.
Which page?
199.
Paragraph 11 is admitted.
Paragraph 11 is admitted. Paragraph 12 is admitted only so far as the agent attended the premises and seized the goods to the value of 10,000, etc., etc. It then goes on. A cheque was paid, and I mean, it's even more supportive than just looking at the particulars of claim, in fact, because it says the enforcement agents were notified upon their attendance to the premises on 1st of February that the claimant had made a cheque payment of 3,000 in part settlement of the arrears, and therefore only proceeded with CRA in respect of the balance outstanding at that time.
So I'm just trying to... So is there any part of this pleading where it says that it's accepted that CRA was unlawful, as now is now being put forward in this court?
No.
There's nowhere said that CRA was unlawful.
As I understood the appellant's submission, it's a discrete point. It's whether or not the learned judge was entitled to infer matters, or whether they should have been remitted to the county court for issues of fact. Well, the learned judge is entitled to infer those matters pleaded and admitted.
Well, yes, I mean, I think the part that Mr. Cowan takes issue is contained in paragraph 31 of the judgment, Mr. Justice.
Well, yes.
Smith, where he says that so far as the respondent is concerned, the respondent,
That's the tenant.
the tenant, knew, that's the word, that CRA had been commenced by the appellants by the presence of the enforcement agents of the property on the 1st of February 2016. So he says that there wasn't the evidence to support a finding that the tenants knew that CRA had been commenced by the presence of the enforcement officers. Now, it is fair to say it's not actually pleaded in 11 and 12 that the defendants did know that the enforcement agents were there in order to put CRA into effect.
Well, it's not
So
expressly pleaded in
it's
those
not.
terms.
It's
I
not
have to accept
pleaded in
that.
it. So you can't rely on the pleading and the admission as such and just sort of stop there. You have to say, don't you, well, it's somehow an inevitable inference.
My lord, yes.
And
that is
how
what
do
I
you
do
put that? Why do you say it's an inevitable inference?
Well, because the facts known were that CRA enforcement agents had been instructed.
Yeah, but that's not known. That's not known to the tenants. Remember, all that tenants know is that as far as the pleading is concerned, that the enforcement agents arrive. Of course, if they knew what was pleaded in paragraph 11, that would be the end of it. But all they know is that the enforcement agents arrive at the door.
Well, these aren't my pleadings.
No,
But
but
what they say,
you're relying on this as
I
an
do.
admission.
But they say on 18th of January, the defendants instructed enforcement agents to exercise CRA. Now, whether that's at paragraph 11 at 147. So that's prior to the event. Because the enforcement agents attend on the 1st of February. It's 147, paragraph 11.
So this is...
Well, what I'd like to query is why you need to rely upon that statement of the judge in any event, because it's all objective. I mean, what they do know, and this we do get from the pleadings, we do know that enforcement agent turn up in respect of the arrears of rent, obviously sent by the landlord. You can only infer that they were sent by the landlord, and they turn up and they demand they demand payment of the arrears on the basis that otherwise they're going to have to take the goods. I suppose that's why they're there. So all of that is there, but why is that sufficient? I don't understand at the moment, from my perspective, why it's critical that the tenants subjectively have to know it, that they're there pursuant to CRA at all.
Well, I can't see that they do.
Well, so what I'm asking is why you accept my Lord's proposition to you that you are relying upon the last sentence of 31 of the judgment. Why are you relying on it?
Well,
why do you need to rely?
Perhaps I was not as clear as I ought to be. I am, with all due respect, hedging my bets. I'm entitled to my submission. If I do need to rely on it, then I say because of the pleadings. But if I don't need to rely on it, it doesn't.
We need to have a submission. Do you say you? Is it your case you don't need to go as far as that?
Well, yes, it is.
It is your case.
It is my case. I don't need to go as far as that. But if I do, in my submission, the clear inference from the facts as pleaded can make out the findings.
But the reason you don't need to go as far as that is that the only lawful basis on which the enforcement agents could have been there was to exercise crime.
Well, yes, exactly.
Yes, I follow.
And just to add one thing, I mean, the Master of the Rolls was saying that the tenants knew that the enforcement agents turned up in respect of arrears of rent. And that it's also, I think, apparent from the pleadings that they seized goods.
Well, yes,
So they're not just coming along and saying, you know, we'd like some rent. They're coming along to take goods in respect to the rent.
well, yes.
I mean, the pleading in paragraph 11, I won't spend much time on this. I mean, this is ex post facto.
Well,
By now, they know this. They're not pleading that they knew it at the time, paragraph 11.
They're not my pleadings. That's why I began by saying.
Yeah, I mean, I appreciate that, but yeah.
it's
But I
happened-
see the first way you put it.
Unless I can assist your lordship any further, those are my submissions.
Thank you very much. Yes, Mr. Thank you, Mr. Campbell.
Well done. Grateful. I wonder if I might start by hopefully being of some assistance on Doe on the demise of David and Williams. I say assistance because I hope to be of assistance because there was some confusion as to the reference to the day of the demise. It's behind tab 11 in the Respondent's authorities. Now, my understanding is this, and no doubt this can be checked if it becomes necessary, but I hope this helps. My recollection of the way, of the history of the way this worked was as follows, that it was the remedy of ejectment was available only to people with leaseholds. It was not available to freeholders. And so a legal fiction was devised whereby if a freeholder wanted to evict a tenant, the freeholder would demise it to a fictional Mr. John Doe, and then John Doe, who is now a leaseholder under a sort of fictional reversionary lease, could then bring an act in ejectment against well, it's not a subtenant, but effectively the occupier, to avoid having to analyse all of that. And that is the reason why there needs to be, why there was a demise, and that's also the reason why the reference to the evidence at the bottom, towards the bottom of page 143, where it says, to prove the disclaimer, a witness was called who stated that he was sent by the lessor of the plaintiff. Well, the plaintiff is Mr. Doe, he doesn't exist, so the lessor of the plaintiff is Mr. David, who does exist and who is the real plaintiff, as it were. That is, I don't, that doesn't go one way or the other, but that I hope assists to understand how this works. But where that may be relevant in putting together the facts is, firstly, it is important when the action commenced, and it isn't clear from the report when the action commenced. If in fact, as may be the case, that it commences on the day of this fictional demise, because there's no other purpose for the fictional demise other than to start the action, then this is a case in which the distress took place after the action was commenced, in which case it can't be waiver anyway.
Yeah, but then that wasn't the ground of the decision.
It wasn't the ground of the decision, although it is not easy to see what the ground of the decision was. The other point that's worth noting is that if this is being treated as a case in which the landlord has to treat the lease as having ended on the date of the disclaimer in March, distress in November is more than 6 months after that date, and that could be equally why the Act of Anne does not apply. Now, I appreciate that is not stated, that reasoning isn't stated in the judgment. The judgment is very short. It really only decides, firstly, that the Statute of Anne doesn't apply to cases where there's been a wrongful disclaimer. And then it makes a general statement that the mere act of distraining for rent prima facie recognises the distrainee as being tenant of the distrainer at the time of the distress made, which is a general point as to distress generally. So I don't say that the 6 months point was the one that decided the case. I simply put that in to suggest that David and Williams it is perhaps even more uncertain as to what we can draw from it than perhaps was apparent in my earlier submissions. I wanted to reply on Croft and Lumley, which is behind tab 8 of the appellants bundle. My Lord Justice Newey has correctly, in my submission, pointed out that these are opinions of judges who've been consulted by the House of Lords in that case. And of course this is the case in which the court spent some time today trying to draw conclusions from short phrases, and I don't propose to take that much time by any means doing that now. But what I do say is this: page 1472 in the English report version. This is Baron Bramwell. 1470, using the numbers at the bottom, 1472, page 1472, tab 8.
Yes.
This is part of Baron Bramwell's decision. We've already looked at it. The part on which I rely is simply this, that, and this is about, in the last paragraph on page 1472, there's a paragraph starting with the words "the last question," and about 7 or 8 lines down, halfway through the line, is a clause that starts "if with notice." I don't know if your lordships have that.
I haven't got it at the moment. If with notice. It's about the middle. It's about
line
the
8, after a semicolon.
Oh yes, I've got that. Thank you. Yes.
So what Bramwell says this: if with notice he says under circumstances which bind him that he will not avoid the lease, or he does an act inconsistent with his avoiding, as distraining for rent (brackets not under the statute of Anne), or demanding subsequent rent, he elects not to avoid the lease. In other words, he elects to waive. Now, in my submission, that is considering the possibility that distress under the statute of Anne could not be waiver at a time when something is being considered as, in other words, in the twilight period, when the landlord has to act as if the lease has ended.
Why do you say that? So why do you say it's in the twilight period?
Because otherwise the question of waiver is irrelevant. If it's before the breach, or strictly before the landlord has knowledge of the breach, but if it's before the point at which the landlord is put to an election, or it's after the time when there's been an actual termination of the lease, there's no possibility of waiver.
You say that, but why not? I mean, the hypothesis here is that somebody serves a notice to quit, and the landlord then goes in, and the tenant remains in occupation.
Yes.
You serve a notice to quit, it expires. You then go into occupation. You then go onto the premises, and the question is, then, well, have you waived the right to throw the tenant out by virtue of the notice to quit? Because you've gone onto the land and you've distrained on it when the tenant is there.
Well,
That's the issue, because there may still be a relationship with that. Maybe a tenant at will. He may be a tenant for years. Who knows what he is?
Well, my lord, I was coming on to consider my learned friend's example.
I think it's quite an important point we're alighting on. I think this is actually quite an important point, because I think it's essential to your analysis, by virtue of what you just said, that there are no circumstances in which, despite the actual wording of the 1709 Act, there are no circumstances in which you could ever waive the termination of a lease by distraining after it's come to an end while the tenant is still in occupational position. That seems to be an essential part of your analysis.
Well, not only if the circumstances are such that the 1709 Act could have been distress under the 1709 Act, and that's exactly what the words.
I'm not sure you've answered my question. The 1709 Act expressly provides for the landlord to enter the premises after the termination of the lease while the tenant is still there. It doesn't say anything more about it. You say, and I think this is inherent in all your previous submissions, you say, well, the only circumstances in which that the only circumstances could arise where the question of avoiding a lease applies is before the end of the lease, and therefore there are no circumstances under the 1709 Act except in relation to this hypothetical period before the end of the lease when this issue could arise. That's what you seem to be saying, even though the whole point of the 1709 Act is to extend the right to enter while the tenant is there after the lease has come to an end.
Yes. I'm not sure if I say that there are no circumstances, because I would say that some of the requirements of the 1709 Act would have to be there on the facts of the particular case. That may not apply in every case.
If they don't apply, then the 1709 Act has no application.
I'm sorry, I didn't.
If they don't apply, if the facts aren't there, you're not
Yes.
within the 1709 Act.
In which case, it cannot be said that it's being that the rent is being distrained under the statute of Anne.
I think that the word's not under the statute of Anne, just there, sort of out of an abundance of caution, because distress under the statute of Anne at the moment, I don't see how it can be a waiver, because it's occurring after the termination of the lease necessarily, by definition.
Yes,
So, I mean, it's a,
You can waive a notice to quit.
but I thought the lease had to have terminated.
Yes, so that's so you can waive.
Oh, I see.
You can waive a notice to quit. I'm not sure if you can waive it even after it's taken effect or not. But the situation that the 1709 Act is looking at, I believe, is a case where the tenant remains in possession.
Yes.
That's the critical point. Well, not in possession. The tenant. What is the wording? Can we actually look at the wording of the 1709 Act? I think he simply is there. I'm not sure he says he's in possession.
it's tab 1 of the appellants or authorities, and it's section 6 and 7. Section 6 is on the bottom second
Tenant,
page.
where a lessees for years or at will frequently hold over the tenants to the such leases. And whereas, after determination of such no distress can either be made for arrears of rent that grew due on such arrears before the determination. So here's the hypothesis. The hypothesis is that arrears of rent have accrued due before the end of a lease. We're not going to with forfeiture. Before the end of a lease, that lease has come to an end either by expiration of time. I think that's what it's really looking at. It may be by service of notice to terminate. Same thing. So lease it then terminates, and the tenant then remains there in occupation. They hold over. So they could be, I suppose, licensees, tenants at will, tenants for years. I'm not sure what they are, but they're there. And the landlord wants to distrain on the land in relation to that previously accrued rent.
Yes.
And what this says is, may be lawful for any person or persons having any rent in arrear or due upon any such lease for lives or for years or will ended or determined to distrain for such arrears after the termination of the said in such manner as they may have done if such lease or leases had not been ended or determined. So, I mean, it's a slightly odd situation. We would probably have to use quite a lot of architectural analysis and some archaeological analysis of this. But as I understand it, the tenant, he's not got the tenant out, so because the tenant's there. And before he gets without having to go to court to get the tenant out and to apply for arrears of rent, you can simply go in and seize the goods. That's what it's allowing you to do. Now, you can't normally do that unless there's a subsisting lease, but the landlord presumably doesn't want to acknowledge that. I assume doesn't want to acknowledge there's a subsisting lease. I don't know. I think it's sort of cutting through all of this and saying, well, whatever the status of the tenant may be, because the tenant may be there holding over in some other capacity. So I suppose what this allows you to do is, let's say you've got a lease, okay? I think this is what it's getting at. You've got a lease. There are arrears of rent due, and you allow the tenant to stay over. You may even take rent from the tenant, so the tenant is still there, qua tenant, not as a trespasser. But this allows you to go in and to distrain in relation to the rent that accrues not just under that lease, but under the previous lease, which has come to an end. Isn't that what it's looking at?
It's one of the circumstances it's looking at,
It's looking at going onto the land, seizing the goods of the tenant who remains on the land in whatever capacity, in relation to rent due under the previous lease, which is determined.
Yes. It doesn't have to have been a second lease. It could simply be that the tenant is holding over.
You can
But
hold
the
over.
lease-
Yeah, you can hold over.
But the lease must have determined.
The lease must have determined, yes.
So
But
that's why there can't be a waiver.
here's where perhaps I differ conceptually. Of necessity, the landlord waiver is always in a case in which the lease has not yet ended.
Correct.
So saying that the distress could not be under the statute of Anne because the lease hasn't ended doesn't take it any further. What my argument is based on is, and I appreciate it is wide-ranging, that doesn't necessarily make it wrong. My point is this, that the landlord, when exercising distress, could be exercising distress, could be doing something that can be done after the end of the lease. Therefore, because he's doing something which can be done after the end of the lease, even though he's not actually doing that thing, because he's doing something that can be done after the end of the lease, it's not an unequivocal affirmation of the continuation of the tenancy.
Well, that I understood from the start. From your skeleton is
yes.
your submission on ground one.
Yes. So I've made that point, and that's the basis of that part of ground one. The next matter on which I wanted to reply, that this is again, I hope, a short point.
Just so we've got the, I'm going to close this point off. You referred us to Crofton Lumley, page 1472, and you referred us to that part of Baron Bramwell's opinion,
Yes.
where he had these words, not under the statute of Anne.
Yes.
And your proposition was that he had in mind this, what you called a twilight period.
Yes, it must be, because he's talking about whether waiver can exist. I'm not sure if twilight period is the right thing. There is in the law of forfeiture, there's another period called the twilight period, which is when you don't know whether or not relief is going to be
What would you like to call it?
Well, let's call it. Perhaps I should call it the election period.
During the election period.
Yes.
You say that's what he's looking at, whereas this is looking at distress after the lease has come to an end, and the tenant remains holding over, and this gives a right, without proceedings, to go in and to distrain.
Yes.
At the moment, I don't see why you should say that they're thinking about this election period at all. That's what I don't understand. And you assert that, you submit that, but I don't see why it's... Now, it may be he's simply saying that because he's simply saying, well, there is a right of distress under the 1709 Act, which has nothing to do with, at all, with waiver. It's simply a right that accrues due after that particular lease has ended, and it gives you a right to go on. So why is it not just that? Why is he not just saying, well, there is another right to distrain, but it's nothing to do with unequivocal act?
Well,
as a matter of fact, I mean, that is in fact the position, isn't it? Under the 1709 Act, there is a right after the end of the lease, in certain defined circumstances, to go on and distrain. That's nothing to do with waiver.
No, that's right. But he is talking about waiver in that sentence because he's talking about election not to avoid the lease. So he is talking about that the election period, and he's saying that either there can be distress, which would waive because it would be electing not to avoid the lease, as long as that distress was not under the statute of Anne. Now, because he's in that election period, in which by definition the lease hasn't ended, he's positing that there could be not actual distress under the statute of Anne, but a communication by the landlord that it's, as I've put it, akin to or could be distress under the statute of Anne. It's simply allowing the possibility that there could be distress under the statute of Anne during that election period. And that's echoed in...
But it couldn't be.
Sorry?
It couldn't be. Because the lease hasn't determined.
No, but well, that brings me back again to my main point, which is that it's that the landlord is treating the lease as if it's...
We've got the basics. We've got the basic submission. What you said.
And just those words are echoed in 1475 in Mr. Justice Crompton's opinion. Towards it's the last two lines or the last sentence of the penultimate paragraph. So there's a paragraph that starts with the number 714 as being the page number. The sentence immediately before that, a receipt of rent A nominate as rent under the lease, my learned friend referred to this passage, at least if unaccompanied by any explanation, is an unequivocal act of electing to keep the reversion. So that's a clear case where there's acceptance of rent, and there was a discussion earlier about whether that must be rent falling due after the date of the breach. But it's the next words which let's say, echo the brackets in Baron Bramwell's opinion, which is so is a distress, namely it is a waiver, in cases where it can only be justified by the continuance of the tenancy. So it's a question that has to be proved by the tenant in each case as to whether this is distress that can only be justified by the continuance of the tenancy. There must be some sort of distress which cannot be justified by the continuance of the tenancy, and that is the statute of Anne. And that's what I say both of those passages are referring to. They can't be referring in my submission to anything else. Well, I don't need to go that far. They could be referring to a number of different possibilities, of which the statute of Anne is one, and that makes it sufficiently equivocal that I make good my first ground. The next, just two more points on which I wanted to reply. The first of those goes to the forfeiture exception in section 79. Yes. In my submission, the way my learned friend put it demonstrates the fallacy in the respondent's case, because the way he put it is this, that there is no way that CRA could have been exercised after the end of this tenancy, because there is no other way other than forfeiture in which the landlord could have brought the lease to an end. In my submission, that is applying precisely the wrong test to waiver. It is not, as I said earlier, for the landlord to prove that he brought that the lease is at an end, or that he's treating the lease as at an end. It's for the tenant to show that what the landlord is doing is not consistent with is only consistent with the continuation of the tenancy. And put that way, and put correctly that way in my submission, that's what all the authorities say the test for waiver is. There's no need, and in fact it's not appropriate, to consider what method of termination there might have been. There could have been a surrender, for example. There could have been any number of ways in which a tenancy can come to an end. One doesn't need to speculate and rule them all out, leaving only forfeiture. It's simply a question of whether this thing can be done while the lease is continuing or after the lease has ceased to exist. And in my submission, that is because my learned friend is ignoring the third possibility of any act done by the landlord during this election period. And the first possibility being electing to forfeit, the second possibility electing to affirm the lease as continuing, and the third possibility is making no election at all, a neutral act. And in my submission, that is what that's what CRA is because it can be done before or after. It is a neutral act, and it's not. It doesn't need to be an election by the landlord to forfeit the lease, which is why it doesn't matter that CRA can only be exercised after a lease has ended, if that lease hasn't ended by way of forfeiture. The last point on which I wanted to reply goes to the Lulham case, Thomas and Lulham, the last case in the Mill and Friends bundle of authorities, and particularly the judgment of Lord Esher, the then Master of the Rolls. In my submission, my learned friend went much too far in submitting that the statute, the 1852 statute, section 210, creates an entirely new right which only comes to existence when there's a demand and re-entry. In other words, my learned friend seems to be suggesting that one can have waived the right to forfeit for certain rent arrears by distraining or exercising CRA, but not waive a right which has yet to come into existence, which is the right to forfeit under section 210. In other words, that it is a right which comes to existence after the waiver of the previous right. In my submission, that cannot be right because of the wording of section 210 itself, and also because of the bizarre consequences that would flow from such an understanding. Not just bizarre, but contrary to the law, to the common law. Because the important words in section 210, which is behind tab 2 in the appellants authorities, it is in the first two lines, which is in all cases between landlord and tenant, as often as it shall happen that 1/2 year's rent shall be in arrear, and the landlord or lessor to whom the same is due, and here are the words on which I rely for this point, hath right by law to re-enter for the non-payment thereof. In other words, there has to be a pre-existing right, which presumably is under the lease. So this doesn't give a right to forfeit to a landlord who doesn't already have that right to forfeit under the lease, as appears to be suggested, or as maybe the consequences of my learned friend's submission, that this is a new right that springs into existence later. In addition, the words service stands in the place of demand and re-entry, which my learned friend relied upon, which are later on in this section. That's the third line on the second page of this printout, which the service of a written ejectment, which service shall stand in the place instead of a demand and re-entry. That's not saying that the service of the writ of ejectment is standing in the place of the accrual of the right to forfeit. It's standing in the place of the execution of the forfeiture. So it's coming at the right to be granted is coming at the end of the election period, and that must be right, because the bizarre consequences which I alluded to that would flow otherwise would be that if this is an entirely new right to forfeit that only accrues at the date of fulfilment of the conditions, for example, if it only accrues once the 6 months rent has become in arrear, or any of the other various conditions, then it would mean that any waiver of those that had already taken place to forfeit for those. Sorry?
Any waiver of what?
Any waiver of. So let's say there are 6 months of rent in arrears. The landlord then waives the right to collect those, for example, by accepting further rent due that would be due after the date of the breach. So the landlord has now entirely waived the right
To the earlier rent.
to the earlier rent.
Just scrubbed it.
Yes.
No longer entitled to the rent due on the Michaelmas Quarter Day.
Yes, indeed. If my learned friend is right, then and this gives rise, once there are 6 months arrears, to a new right to forfeit, then that waiver would be of no effect, and the landlord would now have a new right to forfeit under the section 210. But that can't be right because of those words that he has to have an existing right.
What is the? What does this go to? Sorry, what does this point you're making go to?
Well, it goes to the point that I made about Lord Isha's judgment, which is that he's not saying that there are two separate rights, one at common law and one under the
He's not
statute.
saying that.
No. What he's saying is that there is a position under common law in cases where the statute doesn't apply, and that's waiver under common law. And then there are cases in which the statute does apply, and that they have their own rules of waiver, which is that distress doesn't.
A right, a separate right. A waiver. Which right are you talking about? A waiver isn't a right. I don't quite. Or non-waiver isn't a right. The right is to go on and to distrain. I'm not quite sure when you're saying they're not two separate rights.
Sorry, I'm talking about the right to re-enter, the right to forfeit.
I don't think Lord Isha's talking about two separate. Is he talking about
Well, I
two
think
separate rights?
he is actually. I think you have to say Lord Isha is wrong. Because he in turn says the statute gives to the landlord, quote, a new, original and independent right,
Yes.
which is not affected by a waiver of the forfeiture previously accrued.
Yes.
So even though that's waived by the distress does not waive the statutory right of re-entry. That's what Lord Isha says. Now, you're submitting to us is wrong.
My lord, I'm not submitting that it's wrong. I'm saying that properly read, his statement is not that there are two separate independent rights to forfeit, but that the statute has created a new original independent right which didn't exist before, namely the right to serve a writ of ejectment without having served a formal demand previously.
And re-enter.
And re-enter, yes. And that in cases where that statute applies, the plaintiff is entitled to levy the distress without waiving his right of re-entry.
But
That's
he has waived
what
his
he
common law rights. Or at common law, he's waived his other rights of forfeiture.
Well, yes, that.
I almost feel as if I'm in Alice in Wonderland now. Mr. Cowan, you're asking me to read Lord Isha as saying the very opposite of the very few words that he's chosen. Tell us why he's wrong, but don't tell us that he's not meaning what he said.
You, as I understand it, in saying why this wasn't of help to Mr. Waldner, says, well, if there had been a prior waiver before the waiver relied on as founding the 1852 Act claim, so to speak, that must be effective.
Yes.
Well, I follow that. At the point at which you undertake the distress that leads to your 1852 Act remedy, you have to have an outstanding right to forfeit, whether at common law. That I follow. But why doesn't? What then is the problem? At the point at which you distrain for the purposes of the 1852 Act, you then waive any right to forfeit at common law, and in place you get the statutory right.
At the risk of taking Alice further down, I'm submitting that that's. I mean, if I need to submit that he's wrong, then I'll submit that he's wrong, and that my submission should replace it. But I'm not submitting that. I'm submitting that it is possible for him to be saying that the common law right of forfeiture. Sorry, the common law right to forfeit and the common law rules of waiver apply to some cases.
He's saying go too fast. He's saying that the what? The common law.
The common law right to forfeit and the common law rules of waiver continue to apply to some cases, namely those in which the 1852 Act conditions are not present. But in those cases in which the 1852 Act can be used, the plaintiff is entitled to levy distress without waiving.
Okay.
So I'm not disagreeing with him that there are two parallel types of forfeiture in existence, a statutory one and a common law one. It's perfectly possible to read what he's saying as being that they exist in different cases, depending on whether the conditions are satisfied in those cases, not that they are existing simultaneously in the same case.
Can I just press a bit further? I think you said, well, Mr. Walder's thesis doesn't fit the Act. But as well as that, you say it's going to produce all sorts of undesirable consequences.
Yes.
And there I thought the argument was, well, it must be an implication of Mr. Walder's case that a pre-existing waiver, which would be effective at common law, wouldn't bar the 1852 Act remedy. Is that your case?
Yes, that was a point I made.
But why would that be so? I don't really understand why that would be right. Why shouldn't a pre-existing waiver be effective for every purpose?
Oh, I'm sorry, I'm saying it is. Yes, I'm saying a pre-existing waiver is.
But why is that inconsistent with Mr. Walder's case?
Because he posits that the 1852 Act gives rise to a right of entry that springs into existence after there's been a waiver of.
Well, he posits, as I understand it, that if you have a pre-existing right of forfeit at the point at which you distrain for the purposes of the 1852 Act, you lose your common law right, and what you get in place is a right to proceed under the statutory procedure. And I can't quite see what unfortunate consequences flow from that.
Well, the fallacy that analysis is based on. It's not a fallacy. The flaw in that analysis, in my submission, is a slightly different point, which is the point I made earlier that the properly looked at, the test for whether or not there's been an election by the landlord to affirm the lease has to take account of.
And that I know is your overarching submission, but
yes.
I don't quite see why Mr. Walder's submission produces these nightmare consequences.
Well, if he's right that I mean, I was perhaps taking too far the extremes of his position, but I understood him to be saying at one point, and maybe if he wasn't saying this, then I don't need to address this point. It's not really necessary for my case, but he appeared to be saying that a new right to forfeit arises under the 1852 Act after there has been a waiver of, and he was also saying that arises upon re-entry and it arises upon the service of the writ of ejectment, which stands in place of demand and re-entry. All I was saying was that would mean that any forfeiture under the 1852 Act, the law of waiver can't apply, because if the new right accrues, as it were, at the very moment that it's exercised, there is no, the election period there is, as it were, a scintilla of time that doesn't exist, and therefore the consequences of Melendez Fred's submission, that it only arises upon a writ of ejectment, would be that the law of waiver is completely cancelled in relation to 1852 Act claims, and my only submission now is that doesn't appear to be the doesn't appear to be the intention of the statute, and that's not an argument that's been
I'm afraid
raised
it's
before.
it's
But
not entirely my fault, Mr. Tenant. I'm miles behind you. So I'm just trying to understand, because I want to get your submissions and really understand them. You took us to section 210, and you made a point, it may be quite an important point, but you had so many other submissions, I'm not sure whether it is important or not. The point you made is under section 210, you emphasised the word that it only applies if that person has a right to re-enter for non-payment of rent. Emphasise that. Now, do I understand from your submissions that you're saying, well, that means that it's a right which has not been waived at common law? Is that one of the points you're making, or not? Have I misunderstood that? So I thought you made a lot of submissions, and I'm trying to disentangle them all. And I thought you at one point you were making the point, which I can understand the submission, which is, well, if by common law the right to re-enter has been waived,
Yes.
because somebody has distrained, this act doesn't save you. Or am I wrong about that?
No, that is exactly, yes.
That is what you're saying.
That is what I'm saying, yes.
Right. So you're saying, and you're saying that Lord Esher couldn't have intended to mean something different. Is that the point you're making?
Yes.
I mean, that's quite a simple proposition. So let me just make a note of that. So section 210 says right by law to re-enter, but mustn't have been waived at common law.
Yes. So if I could posit a...
Well, can I
Bring
make
this
this
up?
up?
Yes.
Because otherwise I'm going to get lost again.
Yes.
Hasn't been waived, and Lord Esher could not have meant otherwise. So is this right? That you're saying the difference between you and Mr. Walder, and bearing in mind your interpretation of Lord Esher, is this, that Lord Esher couldn't have meant, when he said it creates a new right, that it creates a right, under the words of section 210, to re-enter, where at common law he didn't have one, because it had been waived. Is that the point you're making?
Yes.
Or have I missed something else?
No, that is. And
That's the short point.
Yes, that's the short point, and those are the words, the words in the first three lines of section 210 itself that I relied on, because he can't possibly...
Would that mean that section 210 had no effect at all? Because it's a necessary condition of 210, as it was originally enacted, that there had been a distress.
Yes, but...
And so if you have a distress, it will waive the right of re-entry at common law.
Well...
But you've got to have a right of re-entry, half-year rent, and a distress that hasn't got you all the rent. If you say, well, that a distress will waive the right of re-entry, or you have to accept that that's the case of common law, I mean, the section just doesn't work, which is surely the explanation. I mean, I think Lord Esher had this point in mind, which is why he expresses himself as he did.
My Lord, I'm not saying that it's that the same distress, the same act of distress, would both waive the right to forfeit under common law and not waive the right to forfeit under the 1852
The same
Act.
distress would A, waive the right of common law, and B, satisfy the condition of section 210.
Well, my Lord, I'm saying no. I'm not. That's not my
So
submission.
you're saying that a distress wouldn't waive the right of common law.
Yes.
Yes, that's.
Well, in that case,
In my submission, there can't be separate rights to forfeit existing in parallel in relation to waiver because of the fact that it has
That's
to
why
be
I'm
an
trying to stick to
equivocal
that.
act.
This is why I'm starting to get lost
No,
again.
I understand. I think you're saying that the right as it exists, the right of re-entry under section 210 is not a separate right from the common law right of re-entry.
That's
That's the submission.
well, exactly. So the submission is that the right of re-entry referred to at the beginning of section 210 is a right which is enforceable as at the moment of the writ of ejection. And if it's been waived at common law, it is no such right. The counter-argument, but please don't answer the counter-argument, I'm going to put it in. The counter-argument is that what Lord Isha is referring to is, when he's talking about the right to re-enter, is a right to re-enter without reference to common law, without reference to distress for the purpose of section 210, and then the new right is a right without, as you quite rightly say, it's a right without actually peaceably re-entering, but simply serving a writ. And the counter-argument is that in those cases, Lord Isha is saying, yes, it's true, you've lost the right because of distraint in common law, but for the purposes of section 210, it presupposes that you ignore that common law right of distress and you simply look to the terms of the Act. That's the counter-argument. But the main point is, I want to make sure I've got your submission correctly. Is there anything that I have not recorded correctly on this point from your perspective?
If I could be allowed a moment to posit one brief example to illustrate, which I hope may clarify, because I'm not sure whether I have got the point across, which entirely is my fault. And it's this: if there are arrears of rent, then but not yet 6 months rent, there is it is not a case to which the 1852 Act applies. So let's say there are 3 months, or well, let's make it the 4 months rent in arrears, and at that point the landlord distrains. Now the only right that exists are common law rights of re-entry, because there's only 4 months owing. And so the landlord has waived the right to forfeit entirely for those rights under common law. The 1852 Act has no effect so far. If subsequently, let's say he doesn't recover, he goes in but he doesn't recover enough, if subsequently 6 months rent does become in arrears, that is the 4 months originally owing, which he distrained for, and now 2 extra months, he then cannot rely on the 1852 Act in relation to those 6 months of rent, because he's already lost his common law right.
You're simply repeating what I put to your case was. Your case was that at the moment of the writ for ejection, whatever it may be, the written ejectment, there must be a subsisting right to re-enter for 6 months rent.
Yes.
Just
Right,
to be clear,
I want to say that's your case. That I understand. All right, thank you.
Yes.
in your example, there are 2 more months' rent due.
Yes.
In your example, are you assuming that they give rise to a right to re-enter?
Yes. But
I mean, if
well,
the situation
they won't
is...
give right to an independent right to re-enter.
Well, supposing that the lease says in the event of 1 month's rent being due, there's a right to re-enter. You now have a right to re-enter at common law because 1 month's rent is due and 6 months' rent are in arrears. What's the problem?
Yes, I'm sorry. The 2 months rent would give rise to a new right to re-enter, but it couldn't be done under the 1852 Act because there isn't 6 months rent in arrears.
Well, it says,
Because
as often
4 months of them
as
have
it shall
been-
happen that 1/2 year's rent shall be in arrear, and the landlord hath right by law to re-enter. Well, 6 months' rent would be in arrear, and there would be a right to re-enter. I'm not sure I see a problem.
Well, because 4 months of those the landlord is has waived the right to.
He hasn't
forfeit
waived the
for
right to
4
the
months
rent.
out of
He's
it.
only waived the right to re-enter for that rent.
Well, it may be that the example doesn't assist as much as I thought it would. It only occurred to me as I was on my feet. There can be circumstances in which I was simply using that to illustrate that there could be circumstances in which the right to forfeit has been waived for a particular reason, and that therefore has also waived the right to forfeit those arrears, 6 months of which would otherwise be subject to the 1852 Act. Well, that can't happen before the 1852 Act conditions are fulfilled. Those are the that's the consequence of the words in the beginning of section 210. So my example may not have assisted as much as I had hoped, but I hope that your lordships have my solution.
I think I got it. Thank you very much, Mr. Campbell. We will consider our judgments in this matter. When we hand down the judgment on judgments, please do send in corrections for grammatical and textual purposes only. Please do agree a form of order